I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today we are at number 240 on our compilation list. For this compilation, we will be in 3 different judges' courtrooms. Before I give you their names, don't forget to like, comment, share, and subscribe. Commentary will be left in the proceedings where commentary was before. Also, chapters will be added for your convenience. Now, the first judge courtroom we will be in, which is a fan favorite, is the courtroom of Judge Jeffrey Middleton out of the state of Michigan. Second, we will be in the courtroom of Judge George Mertz, which was another channel favorite out of the state of Michigan. And last but not least, another channel favorite, we will be in the courtroom of Judge David Fleischer out of the state of Texas. As always, it is a pleasure for you guys joining me here on Sovereign Citizens Hall of Fame. This is one of those episodes where we got 3 of your favorites here on number 240. So let's go ahead and jump in.
Is he in custody? He was here. David Zambrano.
I think he's outside the door, sir.
All right. David Zambrano. He's busy.
How you doing today?
Doing all right. It's a Tuesday. We got lots to do and we're making progress. Mr. Zambrano, we've had a hard time getting you in here. We got a lot going on here. In file 251521, you got a ticket on July 29th for driving without insurance and no valid license in possession. Those are both written under state statute. On July 25th, you got charged with driving with an unregistered vehicle in file 1523. On July 14th, you got charged with driving suspended and unregistered vehicle. That one's under White Pigeon ordinance. So July was a bad month for you. Then we said this a couple times. The city or the village of White Pigeon in the July 14th case has agreed to dismiss the charges if you plead to allowing another to violate the motor vehicle code. I'm not sure what the county's position would be on the other charges. And frankly, I don't know why they didn't charge him with driving suspended on all 3 days. Let's take a look. And then you'd missed a date and then they reset it and I don't know what happened, but oops. It's the last guy.
Your Honor.
Yes.
I'm appearing here today pro se in the special appearance sui juris and in propria persona. I respectfully assert my rights to represent myself and have my constitutional rights recognized and upheld throughout these proceedings.
All right, well, that's certainly your right.
Thank you, sir.
You live in South Haven?
Actually, I'm a sojourner of the land. I don't have a residency at the
Well, the reason I ask,
I once did,
if
sir.
I need to send you mail, I need to know where to send it.
Right now, I do not have an address.
All right. Well, you do certainly have a right to represent yourself, and I don't have a quarrel with that. What do you want me to do? Set these for a trial? Or set a pretrial on all of these? Some are under White Pigeon ordinance, some are under state statute. You can help alleviate this by getting insurance, getting a license. It looks like you have some out-of-state problems. And you haven't had anything on your Michigan record in a long time. 12 years or more. So how would you like me to proceed here?
What are the charges? Again, all the ones that.
Well, right now, you're not doing a very good job of representing yourself because you don't even know what you're charged with. Let me tell you again. You're charged with no insurance. That's a misdemeanor, punishable by up to a year in jail, a fine of not less than $200 and not more than $500. That was on July 29th. On that same day, they charge you with no valid license in possession, even though your license is suspended. They didn't charge that. No operator's license in possession is a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $100. On July 25th, take a look at that one. One, 5, 2, 3. No, that's the 29th. It's the same as the others. You got no insurance, no ops on person, unregistered vehicle. That was on July 29th. And those are all under state statute. On July 14th, you got another ticket. Take a look at that one. 1560. And that one, they filed a formal complaint that alleges that you were driving suspended and you had an unregistered vehicle. And that is under White Pigeon ordinance. Driving suspended is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. That carries 2 points and it requires that your license be suspended. And then they charge that you have an unregistered vehicle. You could help all of these if you got insurance, a registered vehicle, and worked on getting your license back. So one thing I could do is set all these cases for a pretrial on the same day with the White Pigeon Village attorney and the county attorney and see if they can come to some resolution of all the charges. Is that acceptable to you?
Actually, no, I have a few questions I need answered before we proceed. I don't understand the nature and the cause of this action against me. And I'm is this a civil or criminal? It's criminal.
All right. You were here with your mom and she's here with you. So it's good that you support each other. She asked me the same question, which points out to me that you're not qualified to represent yourself if you don't know the difference between a criminal matter and a civil matter. These are criminal matters. They could result in a jail sentence and a sanction on your driver's license.
Thank you, Your Honor. Should the record reflect this is a criminal action then?
Yes, it is.
Okay. I just got to look at my papers and stuff.
All right.
Nah. So my next question about it is, Constitution grants this court two types of jurisdictions.
Yes. All right, we're not gonna get into this, what I call jabberwocky. It has no legal effect. I don't know where you get it or where your mother got it, from a online source or somebody that told you this, or they're giving you bad information. These are criminal matters. They're not terribly consequential. Normally, you wouldn't go to jail for these, although they do carry a potential jail sentence. You don't necessarily subscribe to our system, but I certainly don't subscribe to whatever you got written on the paper there. I propose we set this for a pretrial, and you try to get a registration and insurance, and then come in and share it with the prosecutor and the city attorney, and see if we can resolve everything. If we can't, we can set it for a trial, including a jury trial, I suppose. It's two different incidents. So it would have to potentially be two different cases. What I propose is you trying to do some things to get situated and have a pretrial with the city attorney and the county prosecutor.
Your Honor, I'm gonna have to object to that. Before we can proceed, I need to know, it's upon the authority of the Sixth Amendment, I need to know the nature and the cause of these charges. Could you tell me if it is a common law?
No, these are statutory offenses written under the authority of the people of the state of Michigan. One of these is under the insurance code, and one is under the motor vehicle code. The others are. And I don't really wish to engage in this discussion. We've got about 40 other people waiting for their case. And you want to talk to me about how many angels can fit on the head of a pin. You're charged with two separate traffic offenses on two separate occasions. You have a right to have an attorney. I'd be happy to appoint one for you, but you don't want one. You want to represent yourself, which is your right, but you don't have the right to waste my time. So if you either want me to set it for a pretrial, I can do that. That would be my preference. Then you can sit down with both prosecutors, ask these questions, and see if it can be resolved. If it can't, we can set it for a trial, either in front of a judge or a jury. So what would you rather do here today?
Well, on the authority of the Sixth Amendment, I'm asking that the court discloses the jurisdiction that I ask.
I just did.
You said it's a statutory jurisdiction?
Yes, you're supremely unqualified to represent yourself in this matter because someone sold you a packet of information that has no relevance in the modern universe that we live in. So I'm gonna set this for a pretrial.
Your Honor, that would be practicing law from the bench if you proceed without me.
I'm a lawyer, I'm a judge, I practice law from the bench. I do it every day, all day. And
I'd like to, I do have a few more questions about this.
I don't have any more time to answer your questions. I have a question for you. What do you want me to do with it? Set it for a pretrial or set it for a trial?
Under a statutory jurisdiction, I've never heard of, I need to know where I can find the published rules of the criminal procedure under that.
Well, you can certainly find them on the internet. They're in the public library. you just put the number of the citation, 257904 under the Michigan compiled laws. All right,
Was that
Mr. Stickley is the chief public defender. He's had an opportunity to talk with you. Mr. Stickley, what's your recommendation here?
My recommendation would be to set it for a pretrial. I'm happy to spend a few moments with this gentleman and show him where the statute is
All
and maybe
right.
where he can Google or library.
And he's entitled to have copies of each of the tickets and the complaints, and so he can see it. So if you'd like, we'll get copies of their tickets for you. You got the ticket, but there's a formal complaint. I'm gonna set it joint with the city and county for 2 weeks. October 7. Mr. Stickley is the chief public defender, and he's not exactly representing you, but he's here to make sure that your rights are protected. And he also can give you some advice and maybe point you in the direction of what you want to do. Again, it would be helpful if you would come in with insurance and a proper plate and perhaps an effort to get your license back. You don't want to stay on the driving suspended merry-go-round because it's very hard to get off of it. Once you get suspended, you live near White Pigeon. The other problem is I don't have an address for you, so I need a mailing address. When you go out to the, we can use your mom's address, but I'm gonna need you to give the clerks some sort of address where we can send things to you.
Could you deliver it general delivery to the post office?
Well, you can give them that.
Okay.
All right, I'm gonna want you to take him out, get him a proper notice for that pretrial on the 7th. Mr. Stickley will meet with you and get some of that information that you're looking for. All right, sir, I'll see you on the 7th.
All right, sir, are you Glenn Kendall?
Yes, I am.
Okay. Second. And Stacy, are you ready to proceed?
I am, Your Honor. Thank you.
Okay, so we'll go on the record. This is the matter of Simmons versus Kendall, and this is file number Kalkaska County file number 11-10852. I'm conducting this hearing on behalf of Judge Boudet today. The record should reflect that Mr. Kendall is present in the courtroom in Kalkaska along with Ms. Leach from front of the court. Mr. Kendall, you're before the court today for an arraignment on a bench warrant for failure to pay child support. Do you understand why you're before the court today?
No, I don't. I understand this is a civil infraction, and I don't know why I'm being held on a civil infraction that is a payable debt.
Okay.
It's unlawful. It's unlawful to arrest somebody on a civil infraction that even the officers are saying this is a civil infraction that I should not be in here.
Okay, it's not a civil infraction, and there are criminal penalties for failure to pay child support. So the law says that you can be incarcerated for failing to pay child support for various reasons. So you're incorrect on your statement of the law there.
That's what I was told.
Well, you were
That it was
told
a civil
wrong.
infraction.
Okay, I'm informing you.
And your officers are even saying that it's a civil infraction.
Okay, if
Child
they
support
said that,
is- Yes.
if they said that, which I'm not sure that they did, maybe that's what you heard, but that may not be what they actually said. I'm a circuit court judge. I'm telling you that the law is, if you're found guilty of failure to pay child support, that's a contempt of court. If it's your first finding of contempt for failing to pay, you could face up to 15 days in jail. If it's
What
a
I don't
second or
understand
subsequent.
is, what I didn't understand about the whole child support is it's supposed to be a mediator between the friend of the court is supposed to be a mediator between the two parents. It's not supposed to be a profit made upon two parents. And as long as a judge is taking the case, they're getting paid for it. I'm wondering why everything I've looked up and all the things like Elon Musk is saying that the friend of the court right now is under suspicion of fraud, and they were looking at that stuff. That's what I've been reading online. So how is it that all this is going on and I'm going to get arrested over a debt that's payable? How is that going to help me? With my wife is sitting out there now, who just ended up having to go to the hospital because she's having a breakdown, because we're both having a breakdown. And now I can't take care of her. I'm the one that gives her medical attention. I'm the one that gives her medicine to sleep at night. I'm the one that makes sure she eats every day like she's supposed to. I'm the one that's always with her. And now I can't even take care of my wife who's sitting there because I'm going to be in handcuffs and sitting in here. How is that going to help me to throw me in jail? Within 45 days, I get out and I'm gone again. I mean, it's not going to help me any by taking away my right to be on the street and actually try to find a job, which I have been trying to do. I have stopped at Bear Trust. I have called all kinds of different places. My brother just said a True Frog and Gaylord is hiring. I'm trying to find a job. And I have no place to stay but my car and an old camper that's falling apart that I'm trying to fix. I don't know what to do. I'm trying to take care of my wife. I'm trying to take care of us, trying to eat, trying to anything. And she's saying I'm looking at 45 days right now. And I'm like, what is that going to do for my wife and that, who has no family to go to now because her rights were taken away from her children and stuff. So she doesn't have anybody that she can go to right now. And I'm the only one there to give her meds and do all that. So basically it's like, give up on life then? What? I'm supposed to wrap and be the next one to wrap a sheet around my neck and say, screw it, because I can't take care of my family. I'm no good for anybody. I'm locked up in here. It's not going to help me.
Okay.
I don't even know how she's doing right now. The best bet for me to do is I have so many days to come back in here again with a job thing every day if I have to. Stop in here and give her a slip. This is where I filled out an application. Because once you lock me up, I mean, it's not going to do any good.
I'm just waiting until you're done, because I do need to tell you what your rights are and so forth about how we're going to proceed. So can I do that now?
I'm just.
Okay. So as a parent of a child, you have an obligation to support that child financially. And that's what the friend of the court does, is ensure that parents are meeting that obligation, that legal obligation. And to that end, the court issued an order that required you to pay child support. When you fail to obey an order of the court, you get charged with contempt, and contempt is punishable. In this case, if it's a first finding of contempt for failure to pay child support, of up to 45 days in jail. If it's a second or subsequent, up to 90 days in jail. So that's the legal authority for the court to incarcerate you. You do have the right to have a hearing as to whether or not you should be found in contempt. You have the right to have an attorney present at that hearing. And if you want to have that hearing, then I would set a bond that you would have to post or remain in jail until we can have that hearing.
Can I also ask for a paternity test to be done? I want to know this kid is mine then. I've never had that done. I haven't seen her in 10 years. I have to, if I have to pay every time, I know I'm supposed to have rights to see my child. I don't even know what she looks like, Your Honor. I haven't seen my daughter in over 10 years. I have no clue even how pretty she is or how smart she is or anything. I don't even know what she looks like. I haven't seen my daughter. I don't even know her.
Okay, we're not going to deal with any of that here today. We're trying to figure out how we're going to go forward with this contempt charge. Let me ask Ms. Leach. Ms. Leach, do you have a recommendation? I mean, how did you want to go forward today? Did you want to proceed with the contempt proceeding?
I would, Your Honor. Would you like some of the background information that I have?
Yeah, please.
Mr. Kendall has a monthly obligation of $475. His arrears at this time are $8,915.05. Last payment we received on this case was in June of $289.88. I did speak with him this morning on the phone. He had told me that he at one point had moved to North Dakota to take a job out there. He claims that he didn't stay out there because the guy was abusive to his wife, but he came back here. He told me this morning that he's living in a fifth wheel camper that's really nice, that he's been doing some remodeling on it. He told me that he was given a car by his wife's mother. He did mention that he's gone to a few places to apply for work, but he also mentioned to me that he's been back in Michigan for about a month now. And the few places that he's told me that he's gone and looked for jobs doesn't seem to me that he's really putting out the effort to be out there finding a job. I mean, most people would be pounding the pavement every single day. We don't have anything that states that he can't work in any capacity. We don't have any doctor's note. We have nothing from him in that. We don't even have a good address for him at this point.
I don't have.
We would be asking for a finding of contempt. He has had multiple bench warrants on this case, but he has not had a previous finding of contempt. So he would be looking at the 45 days. And then I would just ask to leave the purge amount at the $2,400. That includes the $100 bench warrants cost. And that's what Judge Boudet had ordered on October 6th of 2025.
Okay. All right. So, and I'm not sure, Ms. Leach, how Judge Boudet handles these arraignment hearings, but unless Mr. Kendall wants to admit responsibility and plead guilty to the contempt, what I typically do is have it set for a hearing. So that would be my intention today. So, Mr. Kendall, those are your options. I told you what your rights are in terms of having a hearing before Judge Boudet, who is the assigned judge to this case. So you do have the right to have a hearing. You have the right to be represented by counsel because there's a potential criminal penalty here. Or you can plead guilty here today. So how did you want to proceed?
I'm gonna have to plead guilty. I mean, I have no choice. I mean, I obviously didn't pay, but I've been trying to find a job and I just got the car not even 2 weeks. And I've been out hitting the street with the car looking for a job. I just got it where it's got plates on it, just got this for it. And no, the camper's not nice. I'm staying in a camper that's shitty, trying to fix a camper to be nice. The whole back end of it's open right now. And if it starts snowing in the next 45 days and me being arrested, there goes my camper, there goes my stuff. There goes everything. I got no way to take care of my wife.
All right, based on the information regarding the arrearages and statements of Ms. Leach here on the record today, the court finds that you have failed to pay child support out of available resources or failed to exercise due diligence. So the court will find you in contempt for failure to pay child support. The court will impose a 45-day sentence in the Kalkaska County Jail. The court will allow you to be released with the purge amount. And is that the $2,400 purge amount, Ms. Leach?
Yes, Your Honor.
I don't know
Okay,
anybody.
so if you were able to make that $2,400 payment and $100 in court costs, then the court, you would be released immediately and would not have to serve that entire 45 days. Otherwise, you will be remanded to the Kalkaska County Jail for that period of time based on the court's findings here today. And Ms. Leach, will you prepare an order reflecting that finding of the court?
I will, Your Honor, and I will fax it over to your secretary, Jennifer, if that works.
Okay. All right, thank you. That's all for this hearing today.
Thank you. Again, sorry about the confusion with the Zoom.
Okay, no problem.
Good morning, Judge Fleischer. How are you?
Hey, what's new?
We're on that Eaton, that pro se defendant, Mr. Eaton, to go with the discovery that he has come to look at. Our investigator reached out to him. He's in the courtroom right now.
Are you talking about Mr. Middleton?
I'm talking yes.
Okay, hold on a second. Let me get on the record because I don't want to do anything without being on the record. So, Mr. Middleton, come on up.
We will be going on the record, so hold all conversations.
Mona, ready?
Yes, Judge.
All right. Today is time set for discovery. It is November 20th, 2024. It's approximately 11:49 in the morning. I'm going to have you guys announce yourselves for purposes of the record. Please state.
For the state, it's Amber Nathan and
Morgan Harmer. Judge, hold on. Can you have him come over so that I can see him? Amber, right here. Yeah. Okay, go ahead. State it again.
Amber Nathan for the state.
Morgan Harmer for the state.
So what we have here today is we have Mr. Emitom. He is charged with unlawful carrying of a weapon. I want to say today is our third setting or fourth. I think it's our fourth setting today. Mr. Emitom has chosen to represent himself. I have done a Feretta hearing, found that he is and can represent himself. Mr. Emitom, are you sure you don't want a lawyer to help you out? Do you want a lawyer to just stand by to be able to answer any kind of questions? Okay, you still want to represent yourself. Understand that if anytime you would like a lawyer, I'm happy to provide you one at no cost to you that can advise you in any way that you may. So that is always at your disposal whenever you need it. At the last setting, we were working on discovery to see what was available. And the only thing, if I remember correctly, the only thing as way of discovery was an offense report that was in.
So Your Honor, the discovery is in, there is a video, there is a body cam and dash cam that's in. The state has tried to reach out to Mr. Abatom to schedule a time for him to come in to review this discovery. It is the state's policy to not give this discovery out of the office to pro se defendants. He is here today. We can coordinate with our investigators for him to come and look at it, what we have. There is also a motion to suppress filed on the same transaction felony out of this, and that is scheduled for December 15th, I believe, or 9th.
December 12th is my next.
December 12th, okay.
December 12th.
Are you representing yourself in the felony case as well?
Yes.
Okay.
Judge Lacayo did find him competent to do so, and we are having a suppression hearing on the 12th of December for that case.
Okay.
So if the evidence is suppressed, both cases would be resolved based on the search. Because unlawful carry is tied to our transaction. Sure. It is a commission of a felony offense. So if our case goes away, your case goes away.
Are you upstairs as well on his case upstairs?
I'm on the felony case, yes.
You're on the felony case. Okay, great.
I know the last time we was here, I did the suppressed evidence. Are they doing the misdemeanor and the felony together with the suppressed evidence? Because I emailed, I don't know if it's Anna or I have it on my email. I emailed Friday, tried to review the evidence, but I didn't get a response. I got a response to come tomorrow at 1:30. I didn't make it in town till yesterday night.
So the defendant emailed me on Friday and he reached out to review the evidence. I requested a cause number. He provided the cause number and I sent on Monday at 7:20 a.m. Would tomorrow work to review the evidence? Please let me know if you have a preferred time. I'm available anytime after 1:30 p.m.
Here now, is it possible to do it now?
Let me coordinate.
Or perhaps later today, since he's here.
Let me go talk to our investigators, make sure they can supervise him. And
you're here now.
Yeah.
I would, Mr. Emitom, you're set for a suppression hearing, December 12th. You have, at a minimum, got to look at every single piece of evidence that's out there before you even go to your hearing. It would be a fool's errand to go to this hearing without looking at every shred of evidence that's out there, because you have to know what they have.
Yes.
And what they're going to use to prove, you know?
Last setting they did go in the back room and let me see whatever was like the report that was typed up and everything. So
Yeah,
I was able to.
That's
take
just an offense report,
Yeah,
but here he's saying there's body worn camera.
Body worn camera, there's another video as well that was uploaded as evidence. And then I believe there was an image of the stolen check. That was.
You want to talk to your investigator now, and
Yes, I can go
can
down.
you stay here and perhaps maybe like at around 2 o'clock, meet them at the office and then go through all the evidence then? Is that okay?
Yeah, I can do that. I can.
You're here.
Tomorrow. I mean, yeah, I can do that now.
If
You might
tomorrow,
as well-
if you want to come in tomorrow morning,
Yeah,
that gives us time, but he has to confirm with us because ADA Harner has emailed him and he has to make that call. Like he can, I don't know, the body cam could be 4 or 5 hours of body cam because there's multiple body cams. I don't know if our investigator is going to stay till 7 o'clock to review body cam today.
That's a good point.
So
Why
if
don't
you're available tomorrow morning,
we do it tomorrow morning?
Yeah, that's fine. Also, are they gonna have the medical record for the hemp? Are they gonna have the?
So that is the one piece of evidence we're still waiting on, Judge, is the lab for the marijuana.
check the charging instrument.
It's what I'm telling you, it's based on it.
That takes a long time. Mr. Emitom, it takes a long time.
Had the receipts from, because they had Montana Doyle that was claiming that. I do have the receipts and she was my witness. That it said that she was claiming that. It said it in the report, so my witness could come and do the testimony or whatever.
But that's at the hearing.
Okay.
You do that at a hearing. You don't do that here as part of just evidentiary sharing, right? It's not, no one takes testimony now. No one decides.
That's when they said she could do it with the clerk. When I did have her here, they said that the clerk could.
You mean just filing an affidavit?
Or whatever she needs to do to say,
I mean, I can't tell you. You're representing yourself. That's why you usually have lawyers that kind of guide you on how to get evidence admitted, what kind of evidence gets admitted. I can't give you legal advice and they can't tell you either.
Yeah, they said I could submit it to the clerk. That's what they said. The witness could come to the clerk and do.
Who is they?
Or
We didn't say that. All I said is that if you wanted to file an affidavit, yeah, something like that, but.
I could do that.
So can you talk to your investigator, see
Yes, I'm gonna do that
tomorrow, perhaps like at 9 o'clock in the morning?
9 o'clock.
So he goes at 9 o'clock. That way it's early. He can stay for as long as he needs to do it. And then if you guys can also provide me with an address of where he needs to go, what floor, perhaps give me a contact name and number just in case as well. So your investigator. That way, if he should have any issues, he has a contact to be able to speak to someone as well. Because if he tries to go through the regular phone system to talk to man, he'll be beating his head against the wall. Okay, so just hang tight with me, Mr. Emitom. I'm gonna have him talk to the investigator, see what time, make sure 9 o'clock tomorrow is good. We'll find out where you need to go. We'll give you a sheet of paper with time, location, and a contact for you. You go review everything. Our case is now 11/20. Today's November 20th. Do you want to set it for after the suppression hearing, since you guys are going to do that over there?
And honestly, I don't even think that the marijuana was sent to the lab, Your Honor. So
I put in a lab request, Judge, myself. I'm not sure if the officers provided it, but I put in a lab request.
okay, if you put a lab request, like I don't know when the.
We'll cross that bridge when we get there. If the officers aren't doing what they're supposed to be doing, go. You know how I feel about that. So how do you feel about that? We'll set this case maybe one day after your hearing upstairs on the 12th.
Yeah.
And like they said, if you win that hearing, this case goes away. Yeah. If you don't win that hearing, then we'll deal with this case the day after and see how we move forward. Okay.
Okay, thank you, Your Honor.
All right, so we're off the record. All right, so just hang tight for me. I'm going to get all the information for you and then just look at everything that's out there. All right, got to. Okay. Okay. All right. Good luck, Mr. Emitom.
Well, guys, we have come to the end of our proceeding. And as we can see from the competency hearing that was given to Mr. Emitom, he was found competent to represent himself. And even though he has the opportunity to represent himself, it was asked if he wanted to at least have standby counsel, which he denied. But we see later on in this proceeding, he struggles to figure out what it is that his witness needed to do or need to do. And we see him trying to kind of get try to get Judge Fleischer to kind of hint for him what needed to be done. And Judge Fleischer was like, no, this is what you asked for. This is what you wanted. It kind of shows that he should maybe at least take standby counsel. And also we saw Judge Fleischer talk to the prosecutors about the police making sure they do what they need to do when it comes to this case. And we see a lot where the police officers drop the ball in many of the other cases by not showing up and allowing some of these sovereign citizens to walk because they didn't show up. But in this particular case, it has nothing to do with showing up, but with more dealing with providing evidence. So we'll see how that works out. This case actually or this particular continuance was actually a couple days ago, and I tried to find it. I tried to find the update on it. I have not been able to find it yet, but as soon as I do, I will share that with you guys. But the case is definitely still ongoing, and it probably will be ongoing for a while. So hopefully eventually we'll get some of these videos out of the Texas court system so that we can just find out what the conclusion is with this particular case. And with that being said, guys, that's all I have to say on today. This is Sovereign Citizens Hall of Fame. And for now, guys, Sovereign Citizens Court is adjourned. God bless.
I'm not threatening you. Say one more word, and that's 30 days. 30